Well, good afternoon, everyone, and welcome to today's fantastic lunchtime lecture here. If you're with us on the East Coast, we're really so thrilled to have a phenomenal speaker here to join us today as we continue our exploration of the First Amendment as part of our long series exploring the amendments to the Constitution. Before we get started with today's program, my name is Samuel Holliday, and I have the tremendous privilege of serving as Director of Operations and Scholarship for the U.S. Capitol Historical Society. And we're so grateful that many of you have taken time out of your day to join us as we get into these fascinating conversations. Just a brief technical housekeeping matter. We have really come to enjoy connecting with people across the country and around the world as we continue our public history work through Zoom. And there are some ways that we can interact during the course of today's webinar. If you have any questions for the distinguished speaker, Mr. Abrams, you can put those into the Q&A section of the webinar platform. Jane, who you'll meet in just a moment, will be presenting those. She'll be curating and presenting those questions to Mr. Abrams at the end of his presentation. If you have any technical troubleshooting matters, if you feel like you're having difficulty hearing or seeing us during the course of today's program, you can send those troubleshooting questions to me in the chat section of the webinar. So once again, any content questions for Mr. Abrams will go in the Q&A, which look like 2 speech bubbles. And any technical issues will go in the chat, which looks like 1 speech bubble. So now it's my great pleasure to introduce the President and CEO of the United States Capitol Historical Society, Jane Campbell, to start today's program. Jane?
Thank you, Sam. As always, we really appreciate the work you do to pull these seminars together. And the work that Yanni Varanis, our communications director, has done with this particular series. And so we are grateful for the behind the scenes work. And as we talk today, we are continuing our series on the United States Constitution by examining the First Amendment's guarantee of freedom of the press. Our featured speaker, Floyd Abrams, has been described by U.S. Senator Daniel Patrick Moynihan as the most significant First Amendment lawyer of our age. After representing the New York Times in the Pentagon Papers case, Judith Miller in the investigation into the CIA leak, and Citizens United in one of the most impactful campaign finance cases ever heard before the Supreme Court. In his distinguished career, Mr. Abrams has argued before our nation's highest court 13 times. He says he's about to do it a 14th time. Represented a variety of media interests. And for 15 years, Mr. Abrams was the William J. Brennan Visiting Professor of First Amendment Law at Columbia. He was also a visiting lecturer at Yale and at Columbia. Mr. Abrams is the author of Friend of the Court, On the Front Lines with the First Amendment and Speaking Freely, Trials of the First Amendment. In his many accolades, in 2011, Yale Law School announced the formation of the Floyd Abrams Institute for Freedom of Expression, whose mission it is to promote free speech, scholarship, and law reform on emerging questions. Today, Mr. Abrams is going to discuss journalism in colonial America, why the founders believed that freedom of the press was important enough to include in the First Amendment, his own distinguished career arguing before the Supreme Court, and the state of modern media in light of the mounting attacks on the industry and the age of social media. As always, as Sam told you, put your questions in the Q&A and I will pose them to the speaker once his presentation is complete. That said, we are honored, Mr. Abrams, that you have come to be with us today, and we look forward to your remarks and your insights. Thank you very much. Take the stage.
Well, thank you very much. It's good to be here. It's good to take time off practicing law to talk a little bit about how we came to be where we are, and in a sense, where we are with respect to freedom of the press. It's not possible, and it's not useful to even begin to talk about it without talking about the beginnings of our country. And just a word or two about the arguments about whether to have a Bill of Rights at all. It was a big argument. When the individuals from the various states met in Philadelphia in 1787, they were all of one mind on one thing, and that was that the Articles of Confederation had sort of failed as a way to have a new country. There were no coins, federal coins. There was no army. There were no taxes. Anything the equivalent of Congress could do required the approval of all the states. For it to be a country, a functioning country, it was necessary to change course, or better put, I think, to move on. And so there was enormous agreement when they met in Philadelphia that there would be a new way to create a new country. And so they sat and discussed and worked out with astonishing unanimity the notion of having a president, the notion of how long his term should be, the notion of how long members of Congress should sit, and that there should be members of Congress from different districts around the country. I could go on. That was the beginning of it. The idea was that there was a need to reformulate the structure of a governing body, but a governing body of some limited powers. And that's where the Bill of Rights came in. There was no intention on the part of the framers to lose whatever rights people thought they had living in a free country. But there was a big argument, a major argument, which began in 1787 in Philadelphia and continued after then, about whether to have a Bill of Rights, or whether, as Alexander Hamilton argued, the Constitution itself, he said, is a Bill of Rights. Capital letters, by the way, when he wrote Bill of Rights. And so he argued, and a number of people argued, there was no need, after specifying what the federal government could do, to start saying what it could not do, which is what the Bill of Rights are about. It's a list of those things that the government was not to be permitted to do. And so the first part of the argument was, well, shall we have a list at all? One of Hamilton's objections to a Bill of Rights, he said, you know, we're going to start listing things, and later generations are going to have arguments about why we left something out, or whether we purposely left something out. And so he and a number of other very serious framers opposed having a Bill of Rights at all. They said, no one is saying that this new thing we're calling Congress, no one is saying they can take away freedom of the press, freedom of religion, freedom of speech. Why do we have to say they can't do it? Well, we dealt with the issue of the risk of making lists at the time of the framers. They dealt with it with perhaps the least well-known amendment, the Ninth Amendment, which is the Ninth Amendment simply says that the enumeration, the listing of certain rights in the Bill of Rights should not be read, should not be, quote, construed, unquote, to deny or disparage the other rights retained by the people. That was an answer to the argument that you shouldn't have lists at all. But the arguments went beyond that. Should they try? Should they see if they could agree on what it was Congress couldn't do in a document which they all thought was specifying all that Congress could do? So what was the argument in favor of a Bill of Rights? Jefferson, then the ambassador to France, was appalled at the idea, astonished, he said, that this new free country would not have a Bill of Rights. He said a Bill of Rights, I'm quoting now, is what the people are entitled to in every country on earth. And others phrased it in a more suspicious way, frequently focusing on freedom of the press. Why are you not saying that there's a freedom of the press which Congress or the new government couldn't interfere with? What are you afraid of? What do you have in mind? In fact, the argument was made by more than one of the delegates at the Constitutional Convention that this must be done on purpose, and that there was a hidden desire to suppress free press. And free press and freedom of religion, by the way, were the two most talked about areas of where the proponents of a Bill of Rights were saying, you know, we need to be clear. There can be no ambiguity that freedom of religion and freedom of the press were to be protected in this new government. And so we got the Bill of Rights. And we've had, of course, many constitutional amendments since then. But we do go back again and again to what was not at the beginning the First Amendment. Fortunately, the first two amendments initially proposed were defeated, dealing with reapportionment, things like that. So the First Amendment became the 45-word articulation of the most important things that Congress, meaning the federal government, couldn't do. And as a result of other amendments adopted after the Civil War, that was held applicable to the states. And so now, and since the Civil War, since the post-Civil War amendments, we have a situation where the First Amendment is, I won't do it all, but it's 45 words. Congress shall make no law, and then it sets forth what Congress shall make no law about. And of course, freedom of speech or of the press, 5 words, or of the press, were specified in what became the First Amendment as that which Congress couldn't interfere with. And again, Congress coming to mean the president too, the federal government, and then expanded to mean after the Civil War with the Civil Rights Amendments, post-Civil War, we had the same rules applying with respect to the states, cities, police forces, and the like, as apply to the federal government. There remains an ongoing debate on the Supreme Court today as to the central purpose of the First Amendment. There are justices who often agree on how to apply the First Amendment, but really don't agree very much these days on some applications of the First Amendment. Justice Breyer, still justice as we speak, in a very interesting book that he wrote, couched it in terms of how the First Amendment seeks to facilitate democratic self-government. And as such, when Congress passes laws or states pass laws, the court had to focus on that central purpose of the First Amendment. But I would say the majority view, certainly on the Supreme Court today, and in general through our history, has been narrower has been to read the First Amendment with the word no at its center. Congress shall make no law abridging the freedom of religion, the freedom of speech, or of the press. So negatively phrased, and as more often than not interpreted by the Supreme Court, what the First Amendment is about is a limitation on government power, a protection from the government. And legislation that is adopted, I'll deal with a few examples in a few minutes, or other action of the government is weighed against, or to see if it's consistent with, this notion of no law abridging the freedom of the press. Now, one thing which has become more of a topic in more recent years than at the time of the founders is what to make. You're not going to believe this, but it's real life. What to make of which word in what I just said? Congress shall make no law abridging the freedom of speech or of the press. The word is the. Abridging the freedom of speech. What freedom of speech? So some members of the court through the years have said the freedom of speech is what the framers had in mind. What was in England? They liked that part of English protection of freedom. And so the argument has been the freedom of speech was the freedom of speech that we know that we've had and that we don't want to lose. A broader reading, which the court has, I would say more often than not, but not always applied, is to be a little bit looser, to read the First Amendment a little more loosely in its joints, that this was intended to be a limitation on what the government could do, starting with the federal government, and again, after the civil rights amendments of a post-Civil War, state governments too. And that there would be new developments which could not easily be meshed against 18th century life, as we see now, with our major means of communication. And before, not that many years before, but before online speech, what? Radio, television. And before that, and to this day, of course, newspapers. So when we speak of freedom of the press, now, we certainly include, everyone agrees, it includes freedom of the press. The press, as we always understood it to be, pieces of paper with words on them, and in more recent generations, often, maybe generally, written by journalists. But it's never been freedom of newspapers only. It's been the arts, it's dance, it's books, novels by great and non-great authors. It is the whole communicative process. And so the court has cases all the time in which it must face up to questions of the interpretation of the First Amendment in today's world. For example, legislation, not legislation, litigation in Texas going on as we speak about Twitter making certain content modification decisions about carrying President Trump. It decided not to, its new prospective new owner seems to be saying that he'll be doing it. But my point is not a Trump point. It's that a lawsuit was brought complaining about Twitter making what I will call an editorial decision about what to carry and what not. The argument being it violates the First Amendment, it's freedom of speech. Now, the answer that constitutional scholars would offer, I speak confidently, which means I could be wrong, is that freedom of speech, freedom of the press have always meant the government and only the government. Not my telling you, I won't publish something that you submit to me if I'm an editor or if I'm running Twitter. I mean, Twitter can, of course, decide for itself. As we now read, it is likely to change its policy about what is now called content modification. But Texas had taken the position that, by law, basically, that Twitter had violated the First Amendment by not carrying the then President Trump. A federal district judge in Texas 2 weeks ago or so said that lawsuit has no standing at all. Twitter has the First Amendment right. Twitter's the publisher. The First Amendment protects Twitter in deciding what to carry or what not to carry. And yesterday, by a 2-to-1 vote, this is not just editorial, I think I'm just giving it straight, but by a 2-to-1 vote, a very conservative majority of 2 judges out of 3 in the Court of Appeals for the Fifth Circuit, in effect, put that decision on hold, meaning that for now, at least, Twitter is directed to change its policy. I feel very strongly that that is unconstitutional and that it will be held unconstitutional by the Supreme Court. But it's a good example of how alive this issue is, of the degree to which First Amendment issues are arising all the time, and in which there is litigation, constitutional litigation all the time about it. I thought I would mention a few cases that I'd worked on just to give you a sense of the scope of situations in which the courts are called upon to apply the First Amendment. The first, and certainly my first time I was ever in the Supreme Court, what became known as the Pentagon Papers case in 1971, in which during the midst and some very hard days in the war in Vietnam, an opponent or the Secretary of Defense, Robert McNamara, asked the Defense Department to prepare a study how we got into the war in Vietnam. I know you might think that's a good study to do before we go into the war, but we didn't. So a group was formed in the Department of Defense. They did the study. It was 23 volumes, 7,000 words. Every page of which stamped top secret sensitive, because there was some material that could be said that we didn't want the world to see, and perhaps our enemy to see. The author of one of the authors, Daniel Ellsberg, was very much against the war. He thought it was a war crime, and he leaked the document to the New York Times, which took a whole floor of a hotel in New York and spent 6 weeks, maybe 2 months, going through it bringing experts in about what they thought could and should be published, should in the sense of national interest, and could not in the sense of national interest, former CIA, former State Department people. And the Times started to publish articles about the revelations, the central one being that the government had not been forthcoming with the country in the years leading up to and even during the war in Vietnam. The government went to court. The government said there'll be terrible harm to the national interest if the Pentagon Papers are published. They're top secret for a reason. And no newspaper, whatever good faith or not, should be allowed to publish this highly classified document. I was on the New York Times team, sort of the number 2 person in the case, and worked with a professor of mine from Yale Law School, Alexandra Bickel, who argued for the Times in the Supreme Court. We won the case by a 6-3 vote, and the Times continued its publication and commentary on portions of the Pentagon Papers, as they were then starting to be called. And I've always looked back on one moment in the case as a moment of transcendent importance. Justice Potter Stewart asked Professor Bickel a question that went something like this. Suppose when we go back to our chambers, we read these volumes and we think that the effect of publishing it will be that a few hundred American young men who had the misfortune of having high draft numbers and who were drafted would die as a result. Are you telling me, Justice Stewart asked Professor Bickel, are you telling me that I have to say the First Amendment allows that? The First Amendment protects that? And I'm just about quoting now, and that these young men should die, unquote. This was Bickel's first argument anywhere, by the way. I mean, he'd never done a divorce case. He tried, as any of us would, to get around the question somehow. I'm sure you won't find that when you read it. It's the sort of answer lawyers give, and hoping that someone on the court will move on to something else. But the risk of it is, and it was shown there, that it irritates the judge. That wasn't what he asked. He didn't ask, will I find this is so dangerous? He asked, if I do find that it's so dangerous, are you telling me I have to allow it to be published? That's what the First Amendment means. Bickel made one more try at that. Stewart was getting upset, and Bickel finally answered by saying, well, in that situation, Justice Stewart, I think that my dedication to the First Amendment would be overcome by my dedication to the avoidance of the loss of human life. I always thought, I still think, that that answer was an absolutely essential one for us to win the case. We did win it, 6-3. 4 members of the court would have gone farther than Justice Stewart and Justice White, who were the judges, so to speak, in the middle. So we had 4, I'd say, for sure, and 3 against us, we know, for sure. And so they were the deciding jurists. And their decision was, in Justice Stewart's words, that you can't have a prior restraint, a limitation in advance on speech. unless the government shows with great clarity that the effect of the speech will be to do enormous harm to the country or its people. That's just one example, of course, a prominent one, of the sort of cases the Supreme Court has to decide in a legal system which does not establish the First Amendment as the only part of the Constitution, and which by its nature sometimes requires a balancing of interests, balancing which is by its nature sort of dangerous sometimes, since it's awfully easy in this case or that to say, well, we don't really need that. I mean, why'd you have to publish that? And it really can do some harm. In another case, for example, that I was involved in, it was a murder case. A young man had small town, Nebraska, had murdered a family there, 6 people, and was on trial for murder. The judge entered a gag order, meaning what it sounds like, that no one could publish certain information, in particular that he had confessed. Now, the issue of the confession would come up at trial, but the press knew, the local press knew that there had been a confession. And heaven knows that's awfully newsworthy in the case, particularly in small town America, where people know each other, knew the deceased family. And if there was a confession, what? You might think it would affect a jury. What the Supreme Court said is that prior restraints, limitations in advance on what the press can publish, are so dangerous and have always been viewed as so dangerous to freedom of the press that only in the most extraordinary case, where nothing else is available to protect the defendant, could you have a prior restraint on speech. And so the trial did proceed, and he was found guilty. And the Supreme Court ruled that because it was this restraint in advance of speech, and because there were other things you could do, you can keep people off the jury. Maybe you hadn't heard about it. The judge can tell the jury in the strongest terms what they're supposed to do and what not to do to be a fair jury. There are lots of other things that could be done, but everybody understands in cases like this, there are risks of always of one side and the other. The risk to the defendant is obvious. The risk to freedom of the press is sometimes more abstract, but we wind up in this country with more protection for the press than exists anywhere in the world. And as my last example, let me just cite one of those cases, and there are many, which have led, and I think every scholar agrees with this, which have led the United States to provide more protection for free speech and more protection for freedom of the press than exists anywhere in the world. So this was a case in which a family that styled itself as a church, the Westboro Baptist Church, you may have heard about them or seen them, had a practice of showing up at funerals of American soldiers who had died in a war, in this case, the war in Iraq I think. And they came with signs outside the courthouse. They stood where the police allowed them to stand, not on the steps of the courthouse, not even 100 feet away, but wherever they were told they could stand, they did. And they had signs saying, in effect, it's a good thing the soldier was killed. This is God's punishment of the United States for being too accepting of homosexuals. Nothing about this soldier, one way or the other way, about this, but this is God's punishment, a deserved punishment. And there were signs denouncing in the coarsest terms gay Americans, and signs saying that the soldier, the dead soldier being grieved that day, within sight of, but as far back as the police said, of that was protected by the First Amendment, and especially protected, Chief Justice Roberts said, because a lot of the signs dealt with gay people in the Army. And that's a public issue, public policy issue, the Chief Justice wrote. And we don't shut people up, whatever pain they cause, within reason, when they comment on matters of public importance, public interest, and the like. That decision was rejected as authority by the Canadian Supreme Court. Canada's law, free country, heaven knows, is much more like England's than ours, much more like Western Europe's, democratic countries in Western Europe than ours. So when they had a case involving a man who denounced a high school board for teaching about homosexuality, he went to jail. Not for a long time, but he went to jail because the attack on gay people in flyers he put out were viewed as being so contrary to public interest that it could be banned and punished. So I cite those cases just by way of example and introduction to you. We do have more protection here than anywhere else. It is not 100% protection. There are a lot of things that we don't allow, but we have sweeping protection as viewed on a world scale for freedom of the press and freedom of speech. On that, this Supreme Court and others that have preceded it in more recent years are all pretty well on board. And I find it interesting as we turn to questions now, how alone we are in the world and the degree to which we do protect freedom of speech to the degree that we do. So thank you all very much. I'd be glad to have any questions or comments.
Wow, you've given us a lot to think about, Mr. Abrams. So one of the things that's on a lot of people's minds as we were in the run-up to this is you represented Citizens United in a free speech case that fundamentally altered our political landscape. With the current makeup of the court, do you see any challenges coming to that 2010 decision, judicial or otherwise?
I get a slight sense of disapproval of that decision in your question, but it's an easy question. If anything, the vote would be more on the side I was on in that case, that rather than less right now. I should say that in that case, which I'm sure you've all heard about, the put it narrowly, what was before the court, a conservative group putting out a sort of a political hit job on Hillary Clinton in 2016. I'm sorry, when President Obama was nominated, when it looked like Hillary Clinton was going to be the Democratic candidate. Very, very, I think all would agree, looking back on it, not just tough, but unfair. How awful she was, and only that, no other side at all. The stuff ordinarily you'd say is protected by the First Amendment, but the group that funded it was a corporation. Corporation funded the conservative group that made this movie and wanted to put it on pay-per-view television. That violated what was then called the McCain-Feingold law, because they wanted to put it on within 60 days of the election, of the nomination within the Democratic Party, 30 days of the nominating process. Under the statute, they couldn't do it. They couldn't use corporate money to speak out about American political issues. I thought and think that violated the First Amendment. It was a 5-4 opinion, very close in every respect. It's a very unpopular opinion by all polling data from the time that it was issued. But if to continue in a sense with how I wound up with my earlier remarks, it is a sign, again, like the opinion or not, of the degree to which we protect what the Supreme Court is prepared to characterize as freedom of speech or freedom of the press. And that is our law now. And this is another example of it.
Well, we appreciate that. One of our listeners is a journalist who began his career in the 1980s. And the perspective of this journalist is that journalism itself has changed in a fundamental way. And they would like to know, what's your perspective on, has it changed? And if so, how? And what, is there a point at which a media outlook becomes exclusively an opinion operation as opposed to a news outlet? And are there any differences in their freedom of speech when they're moved to that area?
The legal question is easier than the journalistic one. No, we don't distinguish between expression of opinions and expressions of purported, at least, fact. It's all protected. Now we have libel law, but libel law, again, we don't have time to go through a whole course in this, but libel law, again, which is more protective of the press than anywhere else in the world, that is something that the very conservative majority on the current court may consider. Two members of the court have already urged that the New York Times against Sullivan, great protector of the press in libel cases, should be overruled. In terms of journalism itself, yes, I think there is more opinion. I think that there is more overt, you could call it editorializing, more overt differences, say, in newspapers. I live in New York. I mean, the New York Post is a right-wing newspaper. I'm sorry, yes, the New York Post. It used to be a left-wing newspaper. The New York Daily News is what? More centrist in any event, without going into characterizations. But what I mean by that is that it is more predictable the way different newspapers would cover the news. Now, to some extent, that's been true, for a long time. I mean, under President Roosevelt, the Chicago Tribune in particular was virulent in what it said about him. And I mean, they were so angry at him. They thought he was so bad, or the publisher did, so bad for the country that in 1941, they published information which almost led to their indictment, because they published information indicating we had broken the Japanese code, something very valuable to us in the Battle of Midway, and used it in a way against the administration. So it's not that it's new, but I do think there is a good deal of less rigid adherence to nonpartisanship in our daily press around the country. I think this is much truer on cable television, where there, I think one can say without qualification, you can come up with words to describe how different Fox News, which has more viewers than any other, than CNN or MSNBC. Whether you call it conservative, right-wing, pro-Trump, all those I think are fair words, and you can use similar language. That doesn't mean, and certainly not for me, it doesn't mean that therefore they're all the same and you can't pass any judgment. You can pass a lot of judgment, but in terms of where the press is, television remains increasingly important vis-a-vis the print press. And of course, online communication is now absolutely central to the formation of public opinion in America. And that's one of the reasons, a central reason, why arguments are so strong, so not just emotional, so important about what sort of, quote, content modification, unquote, policies we should want the Facebooks of the world, the Googles of the world, and the Twitters of the world to follow. The First Amendment gives some answers about what's allowed, but the basic answer of the First Amendment is just about anything. Not everything, but just about anything that people want to say, or to use more pejorative language, spout off on, is available for, and is put on, and is offered to, for the equivalent of publication, these enormous and enormously powerful institutions. And so what their policy is, what they choose in a particular not to carry. I mean, they don't have editorial policies. They have exclusion policies. And the question of who not to carry, what not to carry, how much speech is offensive in a way that that organization, anti-Black, anti-Semitic, anti-Catholic, come up with any examples. They all have to decide that all the time. And the internet is a much more small d democratic institution, in the sense that we're not talking about trained journalists when we talked about the internet. We're talking about the people out there, including people who have biased, sometimes dangerous thoughts and proposals. That is what has led to the notion that some sorts of, again, content modification is necessary. Now, Mr. Musk has indicated that if he does come to take over Twitter, that at one point, at least, he said, I'll be governed by First Amendment rules. We'll see. First Amendment rules basically are just about no rules. And the question then will be for Twitter, what does he do? What does Facebook do? What does Google do? Very, very important questions about the health of our democracy. Yeah.
Well, Mr. Abrams, I'm going to ask you one more question and then the final question, which is something everyone's been asking. So let me give you this one, try to answer it as quickly as you can, because we've got a bonus question for the end. As you talk about content modification and how do we, have First Amendment is no rules. If you look at the question of how do we deal with misinformation, how do we teach people how to determine what's true and not true of the barrage that's coming at them? And the companion of that is, under what circumstances are there real reasons to withhold information? For example, this whole debate that's going on about leaks about what we've done in terms of providing intelligence in Ukraine. How would you see those two matters fitting into the?
Well, first, easy to say, but we need to teach our kids. We need to teach in schools how to read things carefully, how to make sense, how to pass judgment on what's fact and what's opinion, and what seems to be true and seems to be untrue, and how to check things out. Another, easy to say. The second part of your question was, can you give that to me again?
Is there when you have a situation like the leaks that are coming in about intelligence sharing in Ukraine, how would you do that? Well,
I think that posed a very interesting question for the press. I've spent my whole career really representing the press, and my first reaction was I wouldn't have printed it. Now, that may be my last speech for the press. I think it was so dangerous. Now, it was said by a serious source who shouldn't have said it, and by all accounts, to the great displeasure of the president. So an editorial decision had to be made. And I think in general, it would have been published because it came from a reliable source. And I don't want to omit this, it was apparently true. So when do you not publish truthful information on the grounds that the impact of it will be so harmful? And indeed, when do you not publish it when it comes from a source within the government itself? My own reaction is that saying out loud that we were involved in the killing of Russian generals is too dangerous for my thinking about it. And I don't know, how the journalistic community in general, and I don't know how the academic community viewing the journalistic community would come out on that. think probably journalists, distinguished, responsible journalists, would more likely than not said if it comes from a reputable person on the record from the administration, you can publish it. And my sense is, I know you can publish it, but I found it really troubling.
Well, thank you. Now, let me tell you what we're going to do. You told us that you'd be willing to stay for a little bonus time after we finish, and we still have a number of questions. So I'm going to give you the last question of the formal session. We'll recognize that many people have to go back to work, but we're going to come back for a few more questions. But the last question is one that many people have asked me, knowing that you were coming on. Politico just published the leaked draft decision about the Supreme Court's ruling on Roe. Can you sort of take us into the back rooms of Politico? What kind of conversations did they have to have with their legal team before they published that leak? And are there any potential consequences from that publishing, either for them or for anyone involved, from your perspective, looking at it as a First Amendment challenge?
I think that any reputable publication that obtained lawfully the draft, the then current draft opinion, or the opinion being sent around within the court itself, would have made it public. I do. I think it's just too newsworthy not to. Is that something new? Yeah, it is new. And is it harmful? The fact of the leak, not about this particular case even, but more generally, yeah, it is harmful. It's the Supreme Court is one of our great national institutions. The justices basically trust each other and have, for the most part. I mean, not maybe always, but it's been the rule, very much the rule, and not the exception. But I think particularly because it's Roe versus Wade and because of the public interest in that, to say to a newspaper that obtained it that what they would do a story about it but not release the text, I think it doesn't work then. It doesn't work in terms of good journalism then. Either the public should see it or not. And I think this is one of the situations where once the press has it, it's not wrong for it to make it public. Does it do some harm? Well, I mean, of course, institutionally it does. And that comes with the territory. I don't think, my guess is it was not a member of the court who did it, but it's really unthinkable to me. And I don't think that member of the court did it, but whoever it was, whoever it was that obtained a copy illicitly, etc. Seems to me, well, once the press has it, it has it, and that it shouldn't withhold it. What it's going to do to the internal processes of the court is something else. As I said, the Supreme Court's been one of the glories of our system. I don't think it's going to be destroyed or anything by this, but there's no doubt. I think it'll be really harmed. I mean, that process of preparing a draft, sending it around, having people, a draft doesn't have to be read by all 5 of those names that were on it, right? All 5 or all 6. I think it was 5 then. A draft is prepared by someone who's likely to be likely but not surely to be the person who writes the opinion for the court. There are competing drafts often. But the notion of an opinion being leaked does harm the institution. I don't think there's any way around that.
So, Mr. Abrams, thank you so very much. And thank you for being willing to stay for a couple of extra questions. As we close the formal part, we want to thank all our members and friends and donors who have joined us. And we want to alert you that these programs are only available because of your contributions to the United States Capitol Historical Society, and we thank you for that. And we want to let you be aware that our next upcoming program is on the congressional debate about the location and building of the Lincoln Memorial and how we deal with public memory. This is the 100th anniversary of the Lincoln Memorial's, coming to be. And the interesting thing is that then Speaker of the House, Joe Cannon, was not about that particular location. And he spoke in some colorful language about not honoring President Lincoln, who he believed to be the greatest president ever, in that swamp. And so we're going to have some scholars talk about that. And this will be an in-person and hybrid event and virtual event. It's called a hybrid event. We are going to be in the Rayburn House office building. And so look for our notice as we send you information about it. If you register within 48 hours before the event, we will provide you a lunch. And if you can't come, you can also watch it online. So both opportunities are available, and we appreciate so much your help and your support. Now, Mr. Abrams, we could take all day. I know we won't do that because I understand your son has a radio show and he's ready to put you on a little bit later, but we'll do a handful of questions. One of them is, we all have heard about the principle of you've got freedom of speech, you've got freedom of the press, but you can't shout fire in a crowded theater. Now, how does that discussion or that, ruling in the world of law relate to things that someone might say on Twitter that would incite people to violence? I mean, that was some of the rationale for taking some individuals off Twitter.
Yeah, that's a good rationale for taking someone off Twitter. The harder question is it a good rationale for making it illegal? And that's not something that we do. Of course, there are some circumstances in which, speech is such an incitement, intended to be, and with the likely effect of being, that it can get close, but we don't really have that situation. We do have situations, a lot of them, in which President Obama was in a speech at Stanford last week saying, in which disinformation does great harm. Now, disinformation by definition is false information. And the question then of whether we want the Twitters and Facebooks to play, in a sense, a journalistic or even a sort of a journalistic role in saying, we just don't want to carry that because of its offensive quality or because of its potential for danger. Now, again, all means of communication are subject to some degree of legal constraint, but because it's the United States, because of the First Amendment, as it's been interpreted by the Supreme Court, there's enormous freedom to do great harm by speech. And so the question then is, what do we want of the managers, the owners of these entities? My own view is that the public is well served by having internal processes by which decisions are made about certain statements, certain allegations being omitted, even if they could be there without any legal constraint. I think that there is a real societal problem of disinformation. And while I wouldn't want, Twitter or any of the other entities to, fashion themselves as the ultimate truth deciders about all the topics that come up, there are some areas involving group defamation, for example, and the like, which we alone, again, in the world tend to protect, and which I think we're well served by having the proprietors of the people who run those speech machines decide we don't want this on ours. And if there was some way for the public to respond in a way which rewards them, I'd feel a lot better. But at least so far, it doesn't seem as if that is the case. But that in any event is my reaction.
Okay, we're going to do two more questions and then we have to run. And I guess we've talked a lot about misinformation and how to manage misinformation, which brings us to the question about if there were governmental support for programs to teach people how to evaluate if something is misinformation, or if that was included as part of our education curriculum, at what point would that be considered a violation of freedom of speech, or would it?
Well, it certainly would not be a violation of freedom of speech for schools to teach civics again, and
That'd be
for
nice.
And for kids to be taught what to be suspicious of and what not, and what's probably false and what not. I think that's a major role that needs to be performed in an online world, and probably needs more to be done now than it ever was in the past when it was done. So I think that's certainly part of the answer. If the government does it, look, I wasn't upset at the idea of the government, I'll use the word weighing in on disinformation, particularly on sort of medical issues or certain other matters. I think that's fine, and I don't think it has a chilling effect on speech. And if it does, it more often than not probably should in terms of, statements about medicines, health in particular, where I think it is an appropriate role of government to provide guidance to the public. and that is one irrespective of whether someone's violated the law or some law by advocating, taking bleach to solve certain problems.
Well, this is our last question. And, we started this sort of introducing you as the most influential First Amendment lawyer. And the thing that of all the things you've done, you're probably still most famous for the Pentagon Papers argument. And in 2014, you wrote that a majority of the Supreme Court not only left open the possibility of prior restraints in other cases, but of criminal sanctions being imposed on the press following the publication of the Pentagon Papers themselves. And that being said, what is the legal legacy of the Pentagon Papers today? And has that changed? Do we still have that dichotomy between what can be prior restraint and are there criminal actions that can be pursued afterwards?
Yes, we do. And I think the law will likely continue in that direction of putting a very heavy burden on the government in any of its roles, seeking to stop speech in advance, a prior restraint on speech. A censorship regime is, I think, across political, social, economic lines, that's solid, I think. We do have the genuine problem of an Espionage Act adopted in 1917, which is phrased very broadly, which does not impose prior restraints. I mean, but if you say certain things, you can go to jail. Now, it has not been interpreted, or we haven't had cases, a lot of cases in any event, and certainly not in the last century or the last half of the last century, and this one, which sound as if we're at real risk of the suppression of free speech in this area, but you never know. We do have a badly, quickly drafted law during World War I. And once you're out of the area of protecting against prior restraints in advance and into the area of the application of criminal law, at least in the national security area, we still don't have very, very clear answers as to what's allowed and what's not. I mean, the last time the government went to court was under President Carter, in which the Progressive magazine had an issue they were about to publish called How to Build an H-Bomb. The Progressive being at the time, a quite left of center publication, doing this to expose how easy it was as a way to persuade people and countries to do something about the dangers of nuclear proliferation. But the Carter administration, and I suspect just about any other would have, the Carter administration went to court and said, this if there's a secret information how to build an H-bomb, there are a lot of countries that don't know how yet, and that would be so dangerous. And the court initially entered a prior restraint. Then someone found a copy of the same information in some library. And so the government dropped the case. And we haven't had one like that since then. But our current Espionage Act is a 1917 act, and it has significant dangers to civil liberties.
Well, Mr. Abrams, we will watch as things transpire, and we certainly appreciate your time,
Thank
your
you.
talent, and we are so grateful for your being here. For our listeners, be aware that this was recorded, and you will get an opportunity to have the video so that you can share it with your friends and neighbors. Don't forget that we're here only because of your contributions, so make sure you continue those contributions coming so we can continue to provide these fine resources to you. This is a series that we are doing for the next full year to look at all of the amendments to the Constitution, their historical context, when they were enacted, and what they mean for today. So stay tuned as we develop, and we hope you'll join us for the Lincoln Memorial conversation. Thank you again, Mr. Abrams. Thank you, Sam. Thank you, Yanni. We appreciate very much to have all of you with us. Be well. We look forward to our next adventure together. Goodbye.